Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. We are going to dive into this filing by Alec Murdaugh's defense team where they are asking for a new trial citing misconduct by the clerk of court, Miss Becky Hill. We're going to break down, it's 60-something pages. This could be a long one, but I know a lot of my listeners don't have access to this filing in full. And it's probably not something you're going to find read unless you're watching a YouTube channel. So I'm going to hop on and do this now. Music fact of the day coming from the Doors. While recording their first album, Jim Morrison is said to have expressed the fact that they did not have enough original songs. So guitarist Robbie Krieger turned up with Light My Fire the next day. Great song. All right, we're going to jump into this. It is long, y'all. So essentially, Alec Murdaugh's attorneys, Dick Harpootlian and Jim Griffin, have filed a motion for a new trial. We're going to read through this. It says they moved the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror that she believed to be favorable to the defense. Specifically, during the trial, the Colleton County Clerk of Court, Rebecca Hill, instructed jurors not to be, quote, misled, end quote, by evidence presented in Mr. Murdaugh's defense. She told jurors not to be fooled by Alec's testimony in his own defense. Ms. Hill had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, Ms. Hill asked jurors for their opinions about Alec's guilt or innocence. Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. Ms. Hill did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. I do want to clarify one thing here. She did not have a book deal. This was self-published, so I do want to clarify that. Ms. Hill betrayed her oath of office for money and fame. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. Court was not held on February 20th, which was President's Day. After returning from the holiday, Ms. Hill began to enter the jury rooms often. And according to the affidavit of juror number 630, which was taken the 7th of August, that is attached as Exhibit A. As the defense began its case, Ms. Hill told jurors, y'all are going to hear things that will throw you off. Don't let this distract you or mislead you. Additionally, Ms. Hill and juror 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Sometimes they would go into the jury room's single occupancy bathroom together. Foreperson juror number 826 never said anything about the content of those conversations to other jurors. Ms. Hill even instructed jurors that they could not ask foreperson juror number 826 about the conversations. So I just want to throw in here that also it is the jury's responsibility to bring to attention to the court that stuff like this was happening allegedly. Right now, these are all allegations. We do have sworn statements by some jurors at the very end of this, but, you know, they have an oath too. So every morning when they ask, has anybody discussed testimony or the case with you? And they say no. Well, I think those jurors need to be asked some questions as well. If this is just now coming out, and it took the defense knocking on their doors to get the story. 2 days later, on Thursday, February 23rd, and continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began his testimony, Ms. Hill told jurors not to be fooled by the evidence Mr. Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. Ms. Hill also instructed the jury to watch him closely, to look at his actions and look at his movements, which at least one juror understood to mean that Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, Four-person juror 826 told the jury that Mr. Murdaugh was crying on cue. She also criticized the former four-person juror 589 for handing Mr. Murdaugh a box of tissues when he was crying on the stand because that is what the defense wants us to do. The next court day after Mr. Murdaugh's testimony, Monday, February 27th, Ms. Hill told Judge Newman about a Facebook posting she purportedly saw on the evening of Friday, February 24th. That would be the day that Alex testimony concluded on the stand, while pursuing a Facebook group page called Walterboro Word of Mouth. The post, purportedly by Juror 785's ex-husband Tim Stone, allegedly stated that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be. Judge Newman asked her to produce a copy of the posting. She could not produce a copy, but according to Ms. Hill, a subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. It says, "Folks, I posted an ugly post yesterday to which I have deleted, and I kind of in a roundabout way directed it towards a certain person. I would like to apologize to everyone who read it for that ugly for me to do. And yes, I let Satan control me. And I broke down and started drinking. And when I was drunk, I made that post and I'm sorry." And then they refer to her book, Behind the Doors of Justice, on page 97, Timothy Stone Facebook post, February 16th, 2023. The apology post states the initial post was already deleted on February 16th. So it would have been impossible for Ms. Hill to see the original post on February 24th. Mr. Stone, Juror 785's ex-husband, says in a sworn statement that he made no such post. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd of this year to March 2nd of this year, which confirms he did not post the apology. The supposed original post, if deleted, would not be recoverable at this point under Facebook's retention policies, and that he, in fact, never posted anything to the Walterboro Word of Mouth Facebook page during the trial. The person who made the apology post is an unrelated person, also named Tim Stone, whose Facebook profile picture is not Juror number 785's ex-husband. On February 28th, Ms. Hill questioned Juror 785 about the fictitious post on Walterboro Word of Mouth alone in her office in the courthouse. She told Juror 785 that someone had emailed her stating her ex-husband Tim Stone posted on the Walterboro Word of Mouth Facebook page that Juror 785 had been drinking with her husband and that while drunk, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Juror 785 told Ms. Hill that never happened and that she had not seen her ex-husband in 10 years. Juror 785 asked to see the post, but Ms. Hill would not show it to her. Ms. Hill directly asked Juror 785 whether she was inclined to vote guilty or not guilty. The juror said she had not made up her mind. Later that day, Ms. Hill told Juror 785 that Sled and Colleton County Sheriff's Office personnel went to Mr. Stone's house, and he confirmed he made the post. This is a fabrication by Ms. Hill. Ms. Hill told Juror 785 she would somehow reinstate a restraining order the juror previously had against Mr. Stone, which is something that Ms. Hill did not have the authority to do. Still, later that day, Judge Newman examined Juror 785 regarding both the non-existent Facebook post and the tenant/co-worker email. Juror 785 described her interactions with Ms. Hill regarding the Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence. After she was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a jury as opposed to coming to me and bringing it to me. He was right to be concerned." On the next day, March 1st, 2023, the jury visited Moselle, the site of the murders. During the visit, four-person juror number 826 and Ms. Hill walked off to have yet another private conversation. In her book, Ms. Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit to the Moselle property. They quote from her book, While the jurors viewed the Moselle property, we could all hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew. I knew and they knew that Alec was guilty. That day, Judge Newman also held an in-camera conference regarding the tenant/co-worker email in which he decided to revisit the Facebook post issue with Ms. Hill. They go on to put in here some of the transcript of that, the court. Okay, well, let me see what Miss Becky is talking about. I want to revisit the Facebook post you mentioned yesterday. Speaking of a coworker, this is the coworker of a tenant of Juror 785, emailed the court on February 27th stating that the tenant said her landlord was a juror and had expressed an opinion when delivering a refrigerator to the property more than a week earlier. The court asks, that's Becky Hill, the clerk of court. Can you tell us about that Facebook post? Ms. Hill says yes. I think it was Friday evening. Just for a brief moment, I pursued Facebook, got on Walterboro word of mouth, and saw where someone had said that, well, it was the ex-husband of a juror. And he said that he noticed his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be. And then he was the ex-husband, but she was known for talking way too much. Then I just kept scrolling because that was enough for me. I've gotten enough. The court says, how did you determine who he was talking about? She said, when I heard there was an email on Monday, I figured the two went together if it was true. The court said, well, she confirmed she has an ex-husband who she has 3 restraining orders out against. So Ms. Hill said, right. So then we looked on Monday after you told me to try to go back and look for it, and we couldn't find it. But we found out his name and we found the post and printed it out where he said he had put something up, but that he had deleted it at the time and that he had put stuff out there that wasn't nice. The court says he said he got drunk afterwards. Mr. Metters says something about the devil. Mr. Harpootlian says, didn't he say it was Satan in it? Ms. Hill said Satan was in it, yes, and all of the details, yes. The court says, all right. And then Ms. Hill adds, made me do it. Satan made me do it. The court says, okay, I just wanted to have that on the record. You're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got his information from. Ms. Hill says, I don't, but I can find it though. But Ms. Hill never saw any such Facebook post. She made it up. Further, she knew the apology post was not posted by Juror 785's ex-husband. Juror 785 showed Ms. Hill a picture of her ex-husband, which is not the Facebook profile picture of the other Mr. Stone's post about Satan. The next day, March 2nd, the day of the verdict, Juror 785 received a call from her ex-husband that she did not answer. The call upset her because Ms. Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror 7085 asked to speak to Ms. Hill. She told Ms. Hill she was scared. Ms. Hill told her that the Murdaughs probably got to him, meaning her ex-husband. Ms. Hill once again asked her opinion regarding Mr. Murdaugh's guilt. Juror 785 told her that Creighton Waters' closing was good, but she still had questions. Ms. Hill asked what questions, and Juror 785 replied that she was concerned that no murder weapon was found. Ms. Hill then asked, well, what makes you think he's guilty? The juror said Paul's video at the dog kennels. Ms. Hill then told Juror 785 that everything Mr. Murdaugh has said has been lies and that I should forget about the guns. They will never be seen again. Ms. Hill then asked Juror number 785 about the views of the rest of the jury, telling her that if the 4-person would just go in, ask for a raise in hands, this would be over and done with, and everyone needs to be on the same page. Juror 785 went to the jury room and 10 minutes later was excused from the jury. In open court immediately after her excusal, Juror 785 asked Judge Newman if he had spoken with the clerk of court, referring to the conversation earlier that morning with Miss Hill. They have a link in here. It's a video of trial proceedings from March 2nd, 2023. Judge Newman responded, I have not spoken with her today, and that this is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the Facebook post. When the jury began deliberations that evening, Ms. Hill told them that this shouldn't take us long. And if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, and they had previously been allowed to do so during the 6-week trial. But Ms. Hill told them they could not smoke until deliberations were complete. There were 6 smokers on the jury. Ms. Hill told jurors that after the trial, they would be famous and predicted that the media would request interviews with them. Ms. Hill even handed out reporters' business cards to jurors during the trial. Juror 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during trial. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from network news shows. She traveled with jurors to New York City when they appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st, 2023. A last point about Ms. Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with the Colleton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary at the Colleton County Courthouse when it was closed for Confederate Memorial Day on May 10th, 2023. The film crew had previously recorded an interview with Ms. Hill. On May 9th, Ms. Hill sent an email to the film crew purporting to be an addendum to the contract. Memo from Rebecca Hill, May 9th, 2023 was attached. In it, she demanded the film crew pay Colleton County a fee of $1,000 per day for use of the courthouse facilities and make statements about not having authority outside South Carolina that reflects a failure to understand the choice of law clause in the contract. She then bizarrely added a handwritten demand. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of 5-second video and audio clips will accompany the usage on the first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as clerk of court for Colleton County and author of the book. The film crew ignored her addendum as the contract had already been executed, but like her jury tampering during trial, it was an attempt to violate South Carolina Code 8-13-700A, which provides no public official, public member, or public employee may knowingly use his official office, membership, or employment to obtain an economic interest for himself. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. When the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. If the defendant proves the alleged contacts occurred, the prosecution bears the burden to show they were harmless. In a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is for obvious reasons deemed presumptively prejudicial if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial, with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the juror was harmless to the defendant. The presumption is even stronger where the contact was made by a court official, where there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. A state official, Rebecca Hill, the elected clerk of court, had extensive private communications with members of the jury during this trial. This allegation is supported by sworn affidavits of jurors and a witness to juror interviews, testimony at in-camera proceedings, and other evidence, including Ms. Hill's own book. The court, therefore, must hold an evidentiary hearing. If the allegations are proven at the hearing, then under binding appellate precedent, the court must grant a new trial unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The subject matter of Ms. Hill's communications was the evidence being presented at trial by the defense. These improper comments and efforts to influence the juror's verdict vitiated the sanctity of the jury's deliberation and Murdaugh's right to a fair and impartial jury. The court, therefore, must grant a new trial if the allegations are proven. In a 6-week trial, people will talk when they should not. They will say things they should not. Mistakes will be made. The participants in trial are fallible human beings. Lawyers combing the proceedings after the fact will always find they made mistakes and errors. If that were enough to force a redo of the trial, no verdict would stand and trials would be repeated forever. To avoid that, courts properly strain to find that mistakes made during trial are harmless, meaning they did not change the result. But the issues now before the court are not ordinary and inevitable mistakes that occur in any trial. The issue here is that an elected state official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury to secure financial gain for herself. Where a state actor engages in private communication with the jury about the merits of the prosecution, the verdict is impossible to sustain. For example, in Parker versus Gladden, a bailiff told a juror in a murder trial, "That wicked fellow, he's guilty." The Supreme Court of Oregon held the statement did not require a new trial because it was not shown that the statement prejudiced the outcome of the trial. The U.S. Supreme Court reversed, holding the evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's rights of confrontation, of cross-examination, and of counsel. And we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. In this case, the court has declared on the record that the verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence. All of the evidence pointed to only one conclusion. That's the conclusion you all, the jury, reach now. They have a link here to a video of that being said at the trial. The court has therefore foreshadowed the outcome of any harmless error analysis. But the rule for deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. If that were the case, the court would sustain a guilty verdict even if she coerced the jury to vote guilty at gunpoint, because in the court's opinion, all of the evidence pointed to only one conclusion: the guilt of the accused. If the strength of the evidence against the accused in the eyes of the court excuses deliberate jury tampering by a state actor, the result is a directed verdict for the prosecution, a structural error. That cannot be the law. Noting that even if the judge certainly reached the right result, a directed verdict against the defendant would be per se reversible, no matter how overwhelming the unfavorable evidence, because the very premise of structural error review is that even convictions reflecting the right results are reversed for the sake of protecting a basic right. Instead, the law requires the subject matter of the communication to be harmless, clearly harmless. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. Our Supreme Court recently made this point in State versus Green. In Green, during jury deliberations, a juror asked a bailiff what would happen in the event of a deadlock, and he responded the judge would likely give them an Allen charge and ask if they could stay later. The Court of Appeals held the bailiff's comments were presumptively prejudicial because of his official position, but that the state rebutted that presumption by showing for various reasons that the remark did not, in fact, influence the outcome of the jury's deliberations. The Supreme Court affirmed but modified the decision to correct the Court of Appeals' reasoning. The communication was not presumptively prejudicial because the subject matter of the communication was harmless. They include a quote from the ruling. The bailiff's actions here, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. In other words, a bailiff telling the jury that if it's deadlocked, the judge will instruct them to keep deliberating is improper, but likely harmless because the subject matter is procedural or logistical rather than to the merits of the case. Telling the jury not to believe the defendant's defense or his testimony when he testifies regards the merits of the case. Ms. Hill's extensive, deliberate, and self-interested jury tampering far exceeds the simple bailiff mistake that forced a retrial in Cameron, where a bailiff's misleading response to a juror's questions about sentencing options compromised the jury's impartiality because it left the impression that their verdict could not affect the trial court's sentencing decision. Or in Blake by Adams versus Spartanburg General Hospital, where a bailiff told a juror that the trial judge did not like a hung jury and that a hung jury places an extra burden on taxpayers. Unlike the honest mistakes of the bailiffs in those cases, Mrs. Hill had many private conversations with jurors about the merits of the case. She asked jurors about their opinions about Mr. Murdaugh's guilt or innocence. She instructed them not to believe evidence presented in Mr. Murdaugh's defense, including his own testimony. She lied to the judge to remove a juror she believed might not vote guilty, and she pressured jurors to reach a guilty verdict quickly so she could profit from it. Mr. Murdaugh's constitutional right to a fair, impartial jury was violated. The law applied to these facts requires a new trial. So for conclusion, for the foregoing reasons, Mr. Murdaugh respectfully submits the court must hold an evidentiary hearing to receive proof of the facts stated above. When those facts are proven, the court must grant a new trial. Below that, they have affidavits of these jurors they talked to. This is juror 630. Towards the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, including look at his actions and look at his movements, which I understood to mean he was guilty. Immediately after he testified, the four-person juror 826 Mr. Murdaugh was crying on cue. The four-person juror 826 criticized the former four-person juror 589 for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury, we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. The jury frequently discussed the case during breaks before deliberations. Now, mind you, this is the affidavit of that jury. This is not attorney words. This is the juror words. That's a big issue right there. Ms. Hill and the four-person juror 826 had private conversations on multiple occasions. The four-person would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the four-person would go to another room to have a private conversation. The conversations typically lasted 5 to 10 minutes. The four-person juror 826 never said anything about the content of the conversation. For example, she never communicated logistical information after those conversations. This happened 2 more times, more frequently towards the end of trial. When we began deliberations, Ms. Hill told us this shouldn't take us long and that if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until deliberations were complete. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from the television show, and it is blacked out. Which network? This is the affidavit of Holly Miller. She went with Dick Harpootlian and Jim Griffin to meet with these jurors. It says on August 6, 2023, Harpootlian, Jim Griffin, and I met with juror 741 in the case of State versus South Carolina versus Richard Alec Murdaugh at her home. At the meeting on August 6th, The juror indicated she would sign an affidavit. However, we were unable to arrange with her a suitable time and place. During the meeting, the juror relayed the following information to us. During the trial, she witnessed Clerk of Court Becky Hill come to the jury room, and Miss Hill and the foreperson went into the bathroom. After Miss Hill and the foreperson exited the bathroom, Miss Hill told the jurors they could not ask the foreperson questions. Several times during the trial, Miss Hill told the jurors that the media would want to interview jurors at the end of the trial, and during one of these conversations, she passed out business cards from the media to jurors. At the end of the trial, Miss Hill told another juror that no one from the media wanted to interview her. Right before the defense put their case up, Miss Hill told the jurors, "Y'all are going to hear things that will throw you all off. Do not let this distract you or mislead you." After Ellick testified, 8 jurors indicated they did not believe his testimony. Somebody recalled juror 544, known as Boston, by many of the jurors, was very emotional during the trial. During the visit to Moselle, juror 826 and is redacted out walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. There were times the jurors were not kept together, but were in 2 separate rooms. Somebody noticed jurors talking about the case before deliberations began. Neither she nor juror 785 joined in on the conversations about Ellick. As the jury was deliberating, she believes Judge Newman came to the room she was in and told her the jury would have to spend the night at a hotel if they did not have a vote by a certain time, but she does not recall the time deadline. Juror 741 was the first former juror to provide information that the clerk of court made statements to members of the jury about the evidence presented during the trial prior to jury deliberations. Ms. Hill's conduct was verified by other jurors during subsequent interviews. They go back through in their exhibit the testimony Ms. Hill gave about that Facebook post. Then they move to some pieces from her book. They have copies of that in here. She's recounting going to New York City with the jurors, talking about Dustin Lynch, a country music star, was getting ready to appear on the program, and they took photos with him. She talks about this trip being special because it was the first time she'd ever flown on an airplane. She said they flew from Charleston to New York and could order whatever they wanted. I'm not going to read all this stuff. Then they also have this post by this Timothy Stone that apparently is not the husband of the juror. That's the egg lady. We referred to her as that. If you remember, right at the end, she was brought in front of everybody, questioned about this. So they also have an affidavit of Tim Stone, which is the actual ex-husband of this juror. It says, "I did not post anything to the Facebook group Walterboro Word of Mouth between January 23rd and March 2nd of 2023. I did not post anything on the social media page or my own Facebook social media page about his ex-wife being a juror, or that his ex-wife was talking way too much to friends and family about the case, or that Satan had gotten a hold of me and I'd been drinking at this time. I posted and was now very sorry. Nor did I post what is attached as Exhibit A, which has been represented to me to be an alleged post to the Walterboro Word of Mouth Facebook page and a court exhibit in the case. I do not have a Facebook page set up as Timothy Stone. My profile name is Tim Stone," and then he gives a link to his actual Facebook. "I was never contacted by law enforcement, the South Carolina Attorney General's office, the clerk of court, Becky Hill, or anyone at the Colleton County Clerk of Court's office about Exhibit A or a post on the Walterboro Word of Mouth Facebook page concerning my ex-wife. I did not know his ex-wife was on the Murdaugh jury until I heard her voice on a recording where she was being excused as a juror and she was discussing something about eggs. And that ended his affidavit. Also on here, Philip Barber has a post. This is the affidavit of Philip Barber. It says, "Personally appeared before me, Tim Stone. He is being first duly sworn, deposes, and states as follows. I'm an attorney in the firm of Richard A. Harpootlian and counsel of record for Alec Murdaugh. On August 18th, 2023, I met with Tim Stone at his house. He provided his Facebook login information and allowed me to download a copy of all of his Facebook activity from January 23rd to March 2nd, 2023. A true copy of the download is attached as Exhibit A. The contents of the download speak for themselves, but reviews of them shows no post was made on February 16th apologizing for a previous post. There are no posts whatsoever to the Facebook group Walterboro Word of Mouth. Facebook's stated retention policy for deleted posts is 30 days. So any post deleted in the period of January 23rd to March 2nd of this year would not be recoverable. There is another affidavit by Juror 785. This is the foreperson. I was Juror 785, and during the presentation of the defense case after President's Day, but before Mr. Murdaugh testified in his own defense, Colleton County Clerk of Court Rebecca Hill told the jurors not to be fooled by the evidence presented to the jury by Mr. Murdaugh's attorneys. In late February 2023, Ms. Hill questioned me about a Facebook post on the Walterboro Word of Mouth page. She summoned me to speak with her alone in an office in the courthouse. She told me someone emailed her about a post my ex-husband, Tim Stone, purportedly made, which stated, I made comments to him about the guilt or innocence of Mr. Murdaugh. She directly asked me whether I was inclined to vote guilty or not guilty. I told her I had not made up my mind and that I wanted to hear all the evidence before deciding. Ms. Hill said the post said I had been drinking with my ex-husband and that while drunk with him, I expressed opinions on the guilt or innocence of Mr. Murdaugh. That never happened, and I told Ms. Hill it never happened. I did not go drinking with my ex-husband. In fact, I had not seen him in approximately 10 years. I asked to see the post, but Ms. Hill would not or could not show it to me. I've never seen it, and to my knowledge, no one has. Later that day, Ms. Hill told me SLED and Colleton County Sheriff's Office personnel went to my ex-husband's house, and he purportedly confirmed he made the post. She told me she would reinstate a restraining order I previously had against my ex-husband. I did not know about the apology post referencing Satan until Miss Hill's book was published. I've since reviewed that post and can definitely state the post is not by my ex-husband. He does not go by Timothy. The profile picture is not him, and the phrasing of the post is not phrasing he would use. It appears to be a post by another person who happens to have the same name. It does not appear to be a post to the Walterboro Word of Mouth Facebook page. When Ms. Hill first asked me about the Facebook post purportedly made by my ex-husband, I showed her a picture of my ex-husband. For that reason, I now believe she always knew the apology post referencing Satan was not posted by my ex-husband. On March 2nd, the day of the verdict, I received a call from my ex-husband, Tim Stone, as I was getting on the bus to travel with the rest of the jurors to the courthouse. I did not answer. This phone call upset me greatly, and I asked to speak with the clerk of court, which I did by telephone using bailiff Mr. Bill's phone. I told her I was scared. She said the Murdaughs probably got to him. Ms. Hill then asked me questions about my opinion regarding Mr. Murdaugh's guilt. She asked if I was leaning one way or the other. I told her that Creighton Water's closing was good, but I still had questions. She asked me what kind of questions, and I replied, questions about the guns. She asked what would make me think he's innocent. I stated that no murder weapon was found. She then asked, well, what makes you think he's guilty? I said Paul's video at the dog kennels. She then stated that everything Mr. Murdaugh said has been lies, and I should forget about the guns. They will never be seen again. Ms. Hill then asked about the views of the rest of the jury. She told me if the foreperson would just go in and ask for a raise in hands, this would be over and done with. She said everyone needs to be on the same page. She then again said she would reinstate a restraining order I previously had against my ex-husband and that she would call Judge Newman about the restraining order. I then went to the jury room. Approximately 10 minutes later, I was excused from the jury. During the proceedings, I asked Judge Newman if he had spoken with the clerk of court. He only said, this is not because of your ex-husband. 2 weeks later, I did answer a call from my ex-husband. I angrily confronted him about the post he purportedly made because I knew he had not made the comment he claimed I made, denied ever making such Facebook post, and genuinely seemed not to know what I was talking about. On one day during my jury service, approximately 1 or 2 weeks before the verdict, Juror 864 and Juror 826 were in the single toilet unisex bathroom together for an extended period. They were known to do so frequently to discuss the case. Juror 729 referred to it as A and D time. In the van going to the courthouse, Juror 864 said Special Agent David Owen lied on the stand, but that nothing would happen to him. When we visited the Moselle crime scene, Miss Hill and Juror 826 walked off together, avoiding other jurors in order to have a private conversation. I own a rental property which is leased to 2 tenants. On Saturday, February 18th, 2023, I delivered a refrigerator to the property. I was removed from the jury on the day of the verdict because a coworker of my tenant purportedly said I expressed an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. The tenant then worked at Domino's Pizza in Walterboro, so the coworker would be some employee of Domino's Pizza in Walterboro. I don't know whether the juror actually made any such statement at Domino's Pizza or whether a coworker actually heard any such statement. After I was dismissed from the jury, I spoke with both of them, who stated to me and my husband that the affidavits the prosecution drafted for their signature was not what they said to him. They told me SLED showed up at their home at 10 p.m. after they were asleep, removed them from their home, put them in separate cars, and questioned them. The tenant said he told them I did not say anything about Mr. Murdaugh's guilt or innocence. SLED returned 30 minutes later, again, woke them from their beds to serve subpoenas on them to appear in court the next day. They arrived at the courthouse at 9 a.m. the next day and were held for 9 hours until 6 p.m., when SLED officers or a prosecutor finally presented typed affidavits to them, saying they were their statements from the previous night that had been recorded by dash cams in the patrol cars. They said they signed the affidavits without reading them. As I previously testified, I never discussed the merits of the Murdaugh case with anybody, nor did I express an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator or during any other interaction with them during trial. That was the end of that affidavit. They go back into some transcripts from court. So then this is another affidavit of Holly Miller, who works with Harpootlian and Griffin. It says here, Dick Harpootlian, Jim Griffin, and I met with juror 326 in the case and his mother at her home located at, that's redacted. The following information was relayed to us. Juror 326 was asked if Miss Hill told the jurors not to let the defense mislead them. He did not specifically recall this statement, but he did recall that Miss Hill commented to him and other jurors about the photos that would be admitted into evidence, indicating the images would be disturbing. Juror 326 also stated the jurors were stationed in 2 separate rooms when they were not in the courtroom, and that he was in a room with mostly other male jurors. Juror 326 stated that Miss Hill would visit the other room more often, and he could not hear what she was telling the jurors in the other room. During the trial, Juror 326 and others discussed the case prior to deliberations. He did not discuss the case with anyone outside of the jurors. Right there, that's a problem with your jury. He further commented that some of the jurors were going into their office because of financial reasons and that people were talking to coworkers because coworkers wanted information. Before deliberations began, Juror 326 indicated that minor conversation led him to know who was a yes and who was a no. His vote changed with new evidence. As the jury was deliberating, the bailiff and Miss Hill told jurors they could not take a smoke break during deliberations. There were 6 smokers on the jury. After the trial concluded, a group chat was formed by the jurors, but Juror 326 dropped off of the group chat because there were too many chats. When asked if he thought the clerk of court was inserting herself in the process of the trial, the juror responded, "I can see this." Then they include this email from Becky Hill to these people making the documentary, and we covered that just earlier. So that's kind of the nitty-gritty of this filing. Let me just say real quick, I adore Becky Hill as a person. She is such a sweetheart. I interviewed her on here about her book, and I hope none of this is true. It seems like they've got affidavits from these jurors So this very much could end in a new trial for Murdaugh. My only hope is if it is, it's in Greenville. That would be great because I could just be home and cover this. But if it's not, your girl's going to be wherever it's happening. So I just wanted to go through this filing with you guys because I know not everybody has access and it is a hot topic today. All right, guys, I have another episode coming out tomorrow with starting that Sarah Boone case. We're going to go through the 911 call, the body cam footage, get into that interrogation video. There'll be a second video finishing up the interrogation. Then we're going to start at all the things that have happened since then. There's been some shenanigans with her. She's a piece of work. We're going to cover that. Also be doing an update episode in between there on some current things. I'm trying to make up some ground for taking a week off. We'll see what happens in my life between now and then. I'm hoping some peaceful days though, y'all. All right, we'll see you soon. Have a good one.